welcome along to our very first webinar. This is a session focused on lasting powers of attorney, and we will get cracking now. So if we can move to the next slide, Vicky, we'll get started. So a few housekeeping points to go through quickly before we get on. In the interests of privacy and, well, possibly in some cases decency, I don't know, the audience cannot hear or see each other, so that we can remain confidential and so on. The connection with the seminar is secure, and Vicky, my colleague who's running the session, will now shut the virtual doors so that no one who isn't invited can gate crash. We are recording this session, but rest assured only the presentation and my voice and Simon's will be recorded. We won't be recording any participants as part of that. At the bottom of your screen or device, you will probably be able to see a Q&A button. And please, if you have any questions during the session, if you could click on the Q&A button and type your question. I will pick up on those later on in the session when I hand over to Simon, and we will answer as many questions as we can at the end. So Vicky, my colleague, is in the background pressing those magic buttons and making this work. So thank you to Vicky as well. Right, so if we can just introduce ourselves. I'm Steve Mackie. I know and have spoken many times to virtually all of our attendees. There'll be one or two newer clients that may not know me. I'm one of the two directors of Laine Financial Management, and I'm joined by Simon, whose face you should see on the side of the screen there. Simon Rozzier is one of the LLP partners at Griffith LLP Solicitors, and is in their private client department. So Laine is a firm of chartered financial planners. As you will all know, we're independent, we're directly authorised and regulated by the Financial Conduct Authority, and we are based at the West Wing of 47 Old Steam, Brighton, which happens to be the building belonging to Griffith LLP Solicitors, who we've worked very closely with for at least the last 10 or so years. Griffith have two offices in Brighton and a Hassocks office. They're authorised and regulated by the Solicitors Regulation Authority, and they are a Law Society Wills and Inheritance Quality Scheme participant. So we've worked together for a number of years. Today's agenda, I'm going to give you a sort of Martin Lewis style whiz through of where we are currently in terms of tax rules and current position. I'm then going to quickly cover some of the speculation which we've heard in relation to the upcoming autumn budget. It may well not even happen in the autumn at this rate, but there's lots of speculation about that. I will then hand over to Simon, who will take us through the workings of lasting powers of attorney and Court of Protection deputies, and explain how that works. There'll be questions and answers at the end, which, as I say, I'll collect as we go along. Okay, so a very quick reminder of where we are at the moment for this current tax year. Thankfully, most tax bands, allowances and rates weren't changed from 1920 tax year, although we did see some alterations around the edges. There were changes to the pension annual allowance thresholds for very high earners. Quite generously, we saw the junior ISA limit bump up from £4,368, it more than doubled, and is now £9,000, which is the contribution per year that you can make to junior ISAs. The inheritance tax nil rate band has been 325,000 now for a number of years and will continue to be frozen at that level until April. We are into the fourth year of the new inheritance tax main residence nil rate band. which is now at £175,000 per person. I'll touch on that a bit later. We've abandoned round numbers, and we now have a pension lifetime allowance figure of £1,073,100, the lifetime limit for tax-relieved pension savings for the year. Entrepreneurs relief has been cut right back from £10 million to £1 million. That's the preferential rate of 10% when you sell a qualifying interest in your own business. We've seen capital gains tax reliefs get chipped away where people sell rental properties. So if you're selling a rental property that was your main residence, then some of the reliefs are now limited. Lettings relief only applies where the owner occupied with the tenant of the property, and that final period of capital gains tax exemption has been cut back from 18 months to 9 months, although there are some provisions for disabled people and people going into care to avoid penalising them. Now, we've also got on the next slide if we can move along to that in a second, we also have some changes to stamp duty. So when we went into the lockdown, the residential property market virtually dried up overnight. So as of the 8th of July, there is effectively a special offer on stamp duty to reinvigorate and kickstart the residential property market again. And there has been some evidence that that seems to be working. So there's now no stamp duty on properties up to £500,000 in value. The next 425,000 at 5%, and then the next 575 at 10%. Anything over 1.5 million at a very expensive 12% stamp duty rate. I remind you there that the extra 3% stamp duty still does apply if a purchase results in you owning 2 or more properties. Okay, so quick whiz through income tax. We'll all be familiar with most of this, but we can earn £12,500 a year without paying any income tax. That's our personal allowance, applying to children and adults. The next 37,500 is taxed at 20% or 7.5% if that's dividend income. The next tranche, taking you up to £150,000 of income, is taxed at 40% or 32.5% for dividends. And then over £150,000 of income is at the additional rate of income tax, which is 45% or 38.1% for dividends. There's an odd quirk of the tax system where if your income exceeds £100,000, you start to lose your personal allowance. That lovely 12.5 at 0% starts to get taken away. By the time you get to 125,000 of income, you have lost your personal allowance. And that means that tranche of income pays an effective income tax rate of 60%. A reminder that money in an ISA account, income from money held in an ISA account, whether that's interest or dividends, is free of personal income tax. So that's a really valuable allowance. So pension tax relief currently for those making pension contributions could be at any of these rates, from 0% right up to 60% if you're making a contribution that brings your income down from 125 to £100,000, and that's a really efficient way of making a contribution. Okay, capital gains tax. Currently, we can make disposals of assets and make a profit of £12,300 this year without paying capital gains tax. That's our annual exempt amount per person. Over and above that, we'll pay rates of either 10 or 20% for most assets, depending on where the gain falls when you lump it on top of your income for the year. For property transactions, there are different rates. They are 18 or 28%. For those clients who are trustees or have their own trusts, the allowance for most trusts is half of the personal amount. So 6,150 is the allowance for most trusts, but trusts will pay capital gains tax over and above that figure at the higher rate of 28%. A reminder again, the ISA limit is incredibly valuable, not necessarily 1 year to the next, but on a cumulative basis over a number of years. If you can move money into ISAs, when you make gains in your ISA, they are free of personal capital gains tax. The new rules now apply for reporting disposals of property which give rise to capital gains tax. They used to be reported along with your usual self-assessment on the usual timescales for that. Now, disposals of property which give rise to capital gains will need to be made, reported within 30 days, and the capital gains tax due will also need to be paid within 30 days of completion. Not many people have realised this new rule has now come in. There is no capital gains tax on death. That is something which we quite regularly have to remind clients who assume that there will be. Capital gains tax under the current rules is washed out and rebased on death, which is a really interesting consideration. Now, this quote we love, and we've been dining out on this for the last 34.5 years by the look of it. This is Lord Jenkins' quote: "Inheritance tax is a voluntary levy paid by those who distrust their heirs more than they dislike the inland revenue." Making the point there that it can be avoided with planning, subject to you actually wanting to pass assets to the next generation. And inheritance tax has been a political football, particularly over the last 10 or 12 years. So where are we currently with inheritance tax? Well, we could speak about this for weeks on end and still only cover a fraction of the tax system. But the main points which you need to bear in mind are that we've got our nil rate band of £325,000 per person. For most people, there are some strings attached to that. We've got the new main residence nil rate band, which is now £175,000 per person. Many clients will be aware of the 7-year rule and the time it takes for gifts to fall outside of the equation when calculating inheritance tax. There are also other rules, and one of them is a 2-year rule applying to business relief assets. There are particularly complicated rules about gifting, a whole raft of exemptions, reliefs, and intricacies of the system. It is absolutely ridiculously complicated, and HMRC spend most of their time processing inheritance tax forms which don't actually give rise to any inheritance tax collection or revenue. So the system is recognised as being particularly complicated and cumbersome. So a quick look at the main residence nil rate band, the newest of these allowances. There is an additional nil rate band available for an estate for deaths after 6th of April 2017, when the allowance was first introduced, if your estate is valued at less than £2 million. Now, the main residence is the key bit of the relief here, the key word. It has to have been a property which has been your main residence at some point. And in addition, the property needs to pass to qualifying beneficiaries. So we'll just have a look at who those people might be. Well, they're basically children and grandchildren, but also interestingly can include stepchildren and foster children and adopted children. So you'll quickly realise here that people without children or anyone in these categories cannot take advantage of this additional relief. And that met with some objection when it was first introduced. So it's the value of your interest in the property. So if you had a property worth £500,000 and a mortgage on it of £250,000, then your interest in that property is really your equity in it, that's £250,000. If there are more than 2 main residences or more than 2 properties which have been a main residence at some point, it's up to your executors to choose which one they might use to apply this relief against. And a reminder here, if a property has never been your main residence, it won't be able to qualify for this relief. So you can't apply main residence nil rate band to a property which has always been a rental property, for example. So the clue there is in the name. Now, very fairly, you can transfer unused allowances between spouses in exactly the same way that you can transfer unused main nil rate band of 325. The same principle applies to the main residence nil rate band, even if the first death occurred before this relief had been invented. So that's a very fair system. But a reminder here that if your net estate is valued at above £2 million, this relief is gradually reduced by every £2 that you're over, it's taken away to the tune of £1. So there are limits to this, and there are some opportunities for last minute planning to reduce the net value of estates. So how much is it worth? Well, it's currently worth 175,000 maximum potential figure per person. When we add that to the nil rate band of 325, that gives us this £1 million combined allowances for spouses and civil partners. The £1 million that the Conservatives first threw out as a pledge over 10 years ago now. So this is how they arrive at this £1 million figure. So if you have sold your property and perhaps moved into care or downsized to a smaller property during the course of retirement, then again, quite fairly, you can still claim this provision, but it is a particularly complicated procedure to claim it and relies on lots of records being kept. So if you've moved after the 8th of July 15, when the new system was announced, then you can claim this provision, even if you don't own the property anymore. And you do that by passing the proceeds of sale of the property on to qualifying beneficiaries. It is particularly complicated, and I would not recommend for a second that anyone tried to claim that allowance and tried to negotiate their way through the paperwork. It is an utter nightmare. So I would encourage anybody who needs to claim that relief to get some legal input. Okay, so the main point there being, make sure you keep records if you're selling going into care, or if you're selling and downsizing and releasing capital from a house move. Keep your records of all the sales and purchases after the 8th of July 15. Keep your completion paperwork and conveyancing paperwork in a safe place with your will and legal documents, and make sure that all transactions are properly documented. Okay, so a quick look now at some of the speculation around the autumn budget. We still don't have a date for the autumn budget. It's not going to be before the middle of November at the earliest, but there's talk that if we have a second spike in coronavirus, it might get pushed back anyway. So it could get pushed back as late as the spring of next year. There has been speculation that corporation tax rates might be increased from 19 to 24%. I mean, the government has an extraordinarily high borrowing level at the moment, and there's a general acceptance that tax will need to be raised. Whether or not it's done now or deferred and phased in over time is the question. There is talk of capital gains tax being altered and a reversion to the scheme that we had from the late 1980s for about 20 years, where capital gains were charged to the same rates as income tax. So it's quite feasible we could revert back to that system. Interestingly, half of all capital gains tax collected in the UK is paid by about 5,000 people. Not a massive population of voters to upset by radically changing the system. There's talk of removing the double relief that some assets get, where there's no capital gains tax on death, but then the asset is also free from inheritance tax. That's been seen as particularly generous and up for grabs. I mentioned earlier the inheritance tax system being incredibly complicated. The Office of Tax Simplification has recognised that, and it's up for review currently. Inheritance tax only collects about £5 billion a year in tax revenue. It would need to be radically overhauled to bump that up to make a very significant contribution to tax revenue. Pension tax relief, there's been talk of moving to a flat rate of relief. We might see that come in to simplify the system. There was talk earlier this year about a wealth tax, although Boris Johnson's comments after the summer statement made that seem unlikely now. Council tax, for some reason, is still linked to 1991 property values, or the estimate of what they might have been if the property didn't exist then. That could do with a refresher, everybody agrees. Our view on this is that any tax increases are going to have to be done in a way that doesn't stifle economic recovery. Clawing our way out of this current situation relies on economic recovery, and that needs to be seen before we ramp up the burden of tax. That, I think, will be our saving grace. But what we've come to learn over the last few years, I would suggest, is that anything's possible in life. And many things that have happened over the last 9 months or so have been completely unexpected. So we really need to focus on the things that we can control. So on to my next slide. Let's have a look at what we can get in control of. Well, we can get our finances in order and well organised, as our attendees will already have done. We can keep clear records. I talked there about the main residence nil rate ban, but keeping clear records that are clear enough for other people to also understand is absolutely key. Today's session's about lasting powers of attorney, and I cannot stress enough how important it is that somebody other than you knows how you would want your finances to be managed. It sounds obvious, but I commonly help new attorneys sift through paperwork and files and drawers and documents to try and figure out where on earth they're starting with in terms of the person's finances that they're trying to help. So having someone who knows what's going on and what you want is absolutely critical. So they not only need to know where documents are, but they need to know what your plans are for life in general and what your objectives are. And on that note, I will now hand over to Simon, and Simon will now talk us through lasting powers of attorney and why they are so important. Thank you, Simon. Over to you.
Thank you very much, Steve. To all of the attendees, I'll be coming at you with a few less figures over the next 20 minutes or so than Steve did, although that was very useful and helpful. And I'll be trying to focus everybody's minds on thinking about the future and getting things in place. So as Steve said earlier, my name's Simon Rozzier. I'm a partner at Griffith Smith LLP, and we've worked very closely with Steve and the others at Laine Financial Management for a number of years. As Steve also said, we have also spent lots of time sifting through files and drawers and bags and boxes of paperwork to try and ascertain what people are leaving behind if they're no longer able to manage things for themselves. And so looking at lasting powers of attorney and also court-appointed deputies, we'll be looking at what powers donors of lasting powers of attorney can grant, how deputies and attorneys can be appointed and how they act together, what the procedure is for undertaking that, what the duties of the attorneys and deputies are, and also the timescales and charges, mostly from the point of view of comparing and contrasting the two different methods of lasting powers of attorney and court-appointed deputies. So lasting powers of attorney, they were introduced on the 1st of October 2007, and they brought a raft of changes from what we'd had before in place. Some of you might remember the old enduring powers of attorney that we had before that date. It's important to be clear that any old enduring powers of attorney that were correctly executed before that date still remain valid. But also that at that stage, you could only have a power of attorney in place to cover your property and financial affairs. What the new legislation brought in was a new lasting power of attorney that also dealt with a donor's health and welfare. And I'll be looking at how they differ, and in particular where they can be very useful between the two of them. So a donor can appoint their attorneys to act in respect of both of those, and they can have different attorneys for each role. It might be that you've got people in the family who you think would be better suited to look after your health and welfare, and there are other people who are better suited to look after the paperwork and the finances. But the ways that they can generally be appointed are when we're appointing just the one attorney, they're just independently appointed, and they would act on their own, whether it's in respect of your property and financial affairs or your health and welfare. If we're appointing more than one attorney, so these are the different ways that they can be appointed. So they can either be appointed jointly. Now that means that all of the named attorneys have to make every decision together. Now, it's important to be aware that it is every decision they have to make together there. Now, that might seem like a good thing in some cases where you've got family members with different points of view and making sure they come together to make those decisions jointly between them. But at the same time, if it's logistically difficult, it's more common now that people will have family far flung, living and working in Canada, New Zealand, Australia, all sorts of places all over the world. And even though in this day of coronavirus with electronic signatures picking up pace and things like that, it's often still necessary to get wet signatures in place, and it can become logistically difficult if we've got attorneys appointed jointly. So one alternative to that is to appoint attorneys on a joint and several basis. Now that means that they can make decisions either together or independently of one another. So even if that one of those attorneys is not around to help make a decision or not around to sign a bit of paper, then at the very least, the other one that is available and around will be able to sign and keep things moving forwards. You tend to find anyway that where you've got, say, a couple of siblings appointed as attorneys, they will naturally gravitate to one or two different roles. So one of the attorneys might just be much better suited to dealing with paperwork. They will naturally take on that role. But having the other appointed means that we've got a very useful backup, but it also means that the one that's actually dealing with things and making decisions is more likely to keep the other person involved in the decision-making process and perhaps just keep them in the loop, whether it's via a text or an email or something like that. The last alternative is to appoint your attorneys jointly for some decisions and jointly and severally for others. So you might think that you are happy for one of a couple of siblings to make decisions about the everyday things on their own. Now that might be arranging different utility accounts. It might be making sure that they can transfer sums of money up to a certain level. But you might think, actually, I don't want that one attorney to just have the only say over, for example, selling the main home, the main residence. If somebody needs to go into long-term care, then you might think you'd rather have at least two people making that decision for you. And so that's where we can appoint attorneys jointly for some decisions and jointly and severally for others. As a general rule, you want to try and keep things as simple as possible. So if we have a couple of children and we trust each of them implicitly, then keeping things more straightforward and therefore appointing them jointly and severally would generally be considered to be the way to go. But if you think actually, no, you'd rather have a second pair of eyes look over the larger decisions and larger investments and sums of money that are being moved around, then that's the alternative that's available. And as a last note there, it's a case of should a donor consider replacement attorneys. So it might be the case that we've got, say, three children, they might be in their late 50s. And we've also got a couple of grandchildren that we think, well, they might be well suited if something happens to any of my children. So what you might like to consider doing is appointing those people that are a bit younger and therefore more likely to be around and more able to make those decisions for us, having them there as a pure backup. The reason it's important to consider when a lasting power of attorney is actually being made is because when a lasting power of attorney is made, if you want to later revoke it, you have to do so by deed. It's not a case of just simply tearing it up. It's got to be done by deed, and notice has to be given to the attorneys. So if we can try and cover all of the eventualities at the same time in one document, that's certainly the most suitable way of proceeding. Looking specifically at property and financial affairs LPAs, so these are the ones that the vast majority of clients will go for. They will see these as being the more important ones. As any of you that might have tried to deal with a bank, building society, even utility provider on behalf of somebody else, it can be a complete pain in the backside and not worth even having a go at. So to have an attorney appointed here is usually seen as absolutely vital. And as a general rule, donors will give carte blanche to an attorney to manage their finances as they see fit in the best interest of the donor. So it's always incredibly important to carefully consider who is the most appropriate person to appoint. Now, we can all think probably that there is circumstances in families where you might have some children that you might trust to deal with certain parts of the finances and others where not. And although it might cause sometimes issues within the family, it's always important to make sure that the right people are appointed for you that will carry out your wishes. I can't stress that enough. If you think there are circumstances where actually, it might be suitable for them to act on my behalf, but I want to make sure that there is some sort of oversight or perhaps a limit on what they're able to do for me, you can consider giving restrictions and guidance in a lasting power of attorney. Now, that restrictions and guidance might be to deal with things such as making decisions on certain types of investments. You might limit the value of assets that one donor on their own can sell on their behalf, but specifically say you want two or more to act on your behalf when dealing with certain levels of assets. But equally, you might have trusted advisors around you, whether that's a financial advisor, solicitors or accountants, that you think, okay, well, if I've got an attorney making decisions for me, they might not necessarily be aware of the ins and outs of the finances, as Steve mentioned earlier, in terms of having somebody on hand that's aware of the global picture. And actually, you might like to give them some guidance as to who you think might be best placed to assist them in making any decisions, as opposed to simply just removing it perhaps from one financial advisor and giving it to another who's never had any history of the case before. Specifically with property and financial affairs LPAs, it's important to remember that there are two very specific limitations with them that not everybody is usually aware of. The first of those is that an attorney appointed under a lasting power of attorney is not automatically granted authority to see a copy of the donor's will. Now, you might not necessarily think that's particularly important, but it can become very relevant if, for example, a donor is leaving a specific gift of a property or shares or a bank account in that will to somebody very specific. And if an attorney starts to act and hasn't seen a copy of the will, whether it's because they're not allowed to or because they haven't thought to, and they go and sell that asset, thereby leaving that particular beneficiary not receiving the gift you would wish them to receive, the attorneys can find themselves in a difficult position, but equally they're obviously not following the donor's wishes in that case. So it's important they know what's been put in before. And in addition, an attorney, by very definition, has been appointed by a donor. So they've had authority delegated to them to act on the donor's behalf. What an attorney is not allowed to do is to delegate that authority further. So when it comes to making investments, and this is something that Steve will have seen before, if an attorney wants to make investments on behalf of a donor, and perhaps one of the recommendations made by a financial advisor is that the funds are invested within a discretionary fund scheme. What that means, and I won't pretend to be a financial advisor and understand completely the ins and outs of it, but what you're effectively doing is you're giving authority to that fund manager to buy and sell shares or investments on your behalf, as if they were you. Now, as an attorney, that's not an authority that you are able to give to anybody else. But what you can do is, in the power of attorney, in the guidance section, you can give authority to your attorneys to make those decisions. And whilst it might not be relevant to everybody's circumstances at the moment, you can find that attorneys might start managing much larger sums of money if, for example, they need to sell the donor's main home, the main property. That's when you find it becoming much more relevant, because that's when there might be a much larger sum of money that's no longer suitable perhaps just to be in, the best interest rate accounts and in income bonds and that sort of thing. And actually having a little bit of risk is the right way to go, but a balanced risk, and having discretionary fund managers might be the best way to balance that risk. So what we want to do is we don't want to limit any of our attorneys in the decisions they can make, and the wider powers they have, the more suitable it will be. Coming on to health and welfare LPAs. So I often get asked when we're looking at these, why is this relevant? From the point of view of a donor, they will see their children or grandchildren, whoever is the closest living relative, as being their next of kin. Now, next of kin, whilst carrying a certain amount of weight, doesn't have any sort of legal standing at all when it comes to a person dealing with and helping out with a donor's health and welfare and decisions that need to be made. And if a donor has lost capacity and and decisions are needed to be made in respect of their health and welfare, you'll often find that there will be all sorts of other people will be involved in that care at that stage, whether it's social workers, whether it's doctors, nurses. Now, very often, those doctors, nurses, social workers will involve the family in the decisions they're making, because they don't want to make them unilaterally, because they can often find themselves in a difficult position. The problems can really come if the family disagree with any of the decisions that are being made on behalf of the donor, because obviously the attorneys will know the donor much better than the doctors, nurses who have perhaps only come in to provide care at a very late stage. So what a lasting power of attorney for health and welfare gives is an attorney the right to be involved in that decision-making process and have their voice heard over and above the social worker and doctors and nurses, instead of just being lost in the chaos that can often be going on at that time. So that's one of an example of where they can be particularly useful. The other part where you see them being used in particular is if you've got a donor who has a myriad of health issues, and as people get older, I think it's becoming more and more common that they can be on 6, 12, 18 tablets a day that need to be taken on a Monday, Tuesday, Wednesday, Thursday, Friday, all at different times of day, and it can be confusing for the best of us to work out what's going on. Now, as an attorney under a health and welfare LPA, you would have the right to contact the donor's GP, have a look at the medical records and work out for yourselves what should be done so that you can make sure that everything is being put in place properly, and that there's a check and balance there against the donor who might start to lose their medication, not take it from one day to the next, and that can really help a donor through what can be a very difficult time. So in terms of how health and welfare LPAs work, there are two parts to them. One part specifically relates to life-sustaining treatment. At its very basic form, that's turning the machine on or off again, obviously within a strict framework, but it allows the attorneys to have that right to make that decision. And that's often where you find donors have the most emotive decision to make effectively. That's where they feel very strongly that, no, I wouldn't like to be kept going if there's very little likelihood of me having any sort of quality of life. But equally, some people feel very strongly that they do want to have that opportunity. And they would rather have their attorneys make that decision for them, where they've spoken to them in advance about what their wishes would be, rather than just a doctor or a nurse within the framework that they're operating in. And then secondly, general medical and welfare decisions. So that relates to, as I mentioned earlier, what treatments a donor might receive, to double check medication. It could be to help decide what sort of a care home the donor might go into. And that's part of that decision-making process I mentioned earlier with social workers and doctors, etc. If a person is in hospital and they're looking to discharge them, it's about the attorney having the right to make the decision about what care home is most appropriate for them. And then at a very sort of stronger level, it can extend to things like restricting social interaction. So it might be, for example, that there's an unhelpful person in the donor's life, whether that's a neighbour that is perhaps preying on a vulnerable individual, or a friend that causes them distress. Attorneys have the right to stop people visiting the donor to make sure that they can keep them on the straight and narrow, and perhaps help them start making decisions for themselves again. In terms of the procedure, so there's quite a strict form in terms of what needs to be followed here. So firstly, coming back to what we were talking about earlier, the donor chooses which powers they want to grant their attorneys, and there are separate forms that are required. So there's one form for the lasting power of attorney for property and financial affairs, and another for health and welfare. They're not combined within the two. If a person has got an enduring power of attorney for property and finances that's perfectly adequate, that's fine. And it might just be that a client might like to add to that a lasting power of attorney for health and welfare. So you can have a bit of a mix and match there to a certain degree. At that stage, the donor would choose their attorney, so who they want to act in respect of those two different methods, and also how to appoint those attorneys. So that's whether they should be acting independently, jointly and severally, or a mixture of the two. And then also what restrictions and guidance they might like to give. So that's just coming back to, we want to make sure there are no limitations on our lasting powers of attorney, particularly for property and finances. We want to make sure in most cases that the attorneys can see a copy of the will, and also that they can appoint discretionary fund managers to act on their behalf. Most importantly, and where I've seen these go wrong most commonly, where they've been done themselves, is that they must be signed in a very strict order. So firstly, the donor will sign and they will have their signature witnessed, and then a certificate provider will sign. And a certificate provider is there effectively as a safeguard for the donor, and they confirm that the donor has capacity and understands what they're doing. They're not under any undue influence. There's nobody in the background making them make any of these decisions. And a certificate provider will usually be one of two different people. They will either be a professional, which could be a doctor, a solicitor, somebody like that, who's got experience of dealing in this sort of field. Or secondly, it might be a close friend of the donor who has known them for at least 2 years. It's always worth bearing in mind that if anybody ever queries a lasting power of attorney, whether that's another family member, then the certificate provider will always be contacted as one of the first individuals to make sure that there is some sort of evidence available to show that the donor at the time they entered into this document understood what they were doing and were not being forced into doing it. Once that's happened, the attorneys will then usually sign, and then after that, the donor will often sign to register the document. Now, coming on to registration, now with lasting powers of attorney, unlike the old EPAs, they have to be registered before they can be used. So what some clients will ask is, well, if I just go ahead and prepare the documents and then sort of put it in a drawer and forget about it, is that all right? Is that something that I can do? Well, I mean, it is something that donors can do, but let's not forget that one of the reasons that we're putting these things in place is they're effectively an insurance policy. We hope never to have to use them, but if they do need to be used, then attorneys can pick them up immediately and they can get started making decisions and helping the donor from day one. If they're not registered and therefore they can't be used, the current registration process is taking around 12 weeks. Now, the actual statutory waiting period is around 5, but in practice it's taking an awful lot longer to get these documents through the Office of the Public Guardian, who is the central government authority that deals with the registrations. So we always say to clients, look, if you're entering into these documents, get it registered straight away. One, because attorneys can use it from day one, but secondly, if there are any issues, perhaps they haven't been signed in the correct order, or perhaps there's a box that hasn't been ticked, something like that, that will be flagged by the OPG when it comes to registration. And you can be sure that if there are any issues like that, then the donor can rectify them before they lose capacity and before it gets found out effectively at too late a stage. So best not to just put them in the drawers and make sure that they've been registered. Now, what is the situation if nothing is done? So just coming on to the next slide now. What is the position there? So, well, firstly, no decisions can be made with regards to finances or health and welfare for that matter. And that can be potentially problematic, which I'll come on to in a bit. But also it means that the people who are going to be acting on behalf of the donor are going to need to make an application to the Court of Protection to be appointed as a deputy. That's a very different procedure to lasting powers of attorney. What it's there for is it's there effectively to protect vulnerable individuals. So where a person lacks capacity, it ensures that people can be appointed to act as deputies on their behalf. And it's also there to make one-off decisions on behalf of those that have lost capacity. As with lasting powers of attorney, there are two types that deputies can apply for. One for property and financial affairs and one for health and welfare. But there's a big difference here as compared to lasting powers of attorney, which is that the court really does not like granting deputyship orders in respect of health and welfare. As a general rule, you will not see it happen. And we will usually advise our clients, unless somebody is very specific about what they want to do and they're willing to risk it, we will often advise our clients to not even bother trying to get it, because the court will invariably reject an application for an order like that. Appointment of the deputy. So who's actually going to be making this application? Now, this is where we start to see the first real departure as from lasting powers of attorney, because it's no longer the donor making a decision about who they want to act on their behalf. Instead, it's other people taking on the mantle themselves. Now, it might be that those people will be the ones that the donor would have approved of and would have appointed themselves. But equally, it's entirely possible that it will be people that the donor doesn't want to act for them. And I've seen lots of examples where I've made applications for either relatives, for friends, circumstances where professionals have been appointed, for example, law firms, but also examples where the local authority are appointed, which is something a lot of people aren't necessarily aware of. And where an individual has got money invested for their benefit, what you want to make sure of is that money is going for to provide for additional care and services that might not otherwise be provided. Now, ordinarily, relatives and friends will know exactly what a person wants and be able to put that in place. Professionals will often have that as well, where we've had discussions with clients before who haven't got family that they trust to make decisions for them, or that they haven't got family at all. So we will have a history, we will have letters from the client explaining how they would like us to act. But usually where it's a local authority that are taking on the mantle, you know, they will do the bog standard. They will be appointed to make sure that care home fees can be paid, that things are running, that income tax returns are filed, etc. But they won't generally go much further than that. So that's one of the first big departures that we see. The next big departure that you see is in the procedure. So we talked about the procedure for lasting powers of attorney, which is usually run entirely by the donor and can be turned around in a matter of weeks before registration happens. And that's where we have the period of time where we're waiting. For a Court of Protection application, you start off with a COP1 form, which is the initial application. That's where the deputies fill out what sort of deputyship order they are looking for, for property and finances or for health and welfare. And they will then need to file with that supplementary pages. So a COP1A that I've mentioned here, that specifically relates to the finances. And so what a proposed deputy has to do is collect together details of the donor's finances to be filed with the Court of Protection. Now, I don't know about you, but certainly with a lot of members of family, you wouldn't even know where to start collecting that information together from. So instead of having a power of attorney that's there to be picked up and decisions made from day one, the deputy starts effectively on the back foot, having to collect this information together from the get-go before they can even start making the application and progressing it. A COP3 is needed, which is an assessment of capacity report. That's usually done by a GP or psychiatrist. There can be quite significant delays on getting those completed, particularly where it's done by, for example, the public services, whether it's a GP, etc. And often they're very expensive to have done where they're being completed by a private facility. And also, deputies need to give declarations on a COP4 to show that they haven't been made bankrupt, that they haven't got criminal convictions and things like that, because let's not forget that the court won't know these people from Adam. So the court will require a significant amount of information. There might also be additional forms and evidence required where there are particular peculiarities in terms of joint ownership of assets and things like that. And it might be that deputies will need additional orders from the court to make decisions about those sorts of things, and hence where these additional forms come from. Once all of that information is collected together and the decisions have been made about who's going to be appointed to act, the application needs to be sent to the court, or we call that issuing the application, and then notice needs to be given to interested parties, and that needs to be given to respondents. And respondents are entitled to the application form, supplementary forms, and all of the evidence filed. So that includes details of finances, etc. So not only might there end up being somebody appointed to act on behalf of a donor that they might not necessarily have chosen, but also now their financial information is being sent to an awful lot of other people who they might not necessarily want it to go to. And then we've got people that are also notified. These are all listed in the application form, and there is again a statutory waiting period. So we issue our application, we have to wait for that to come back from the court, and we then have to give notice to these various named people. Once notice has been given, that is then confirmed to the court. That can often take a period of months. Again, the statutory waiting period is a number of weeks, but in practice it's more like months. And the court will then generally grant an order where there's nothing too out of the ordinary that's going on. Once the order has been granted, the deputies will be required to obtain a surety bond. And a surety bond is provided by approved insurers, and they effectively provide protection for, in this case, we've referred to them as the patient or the donor, against the deputies failing in their duties. Because again, we don't know who's going to pick up this file. The court doesn't know who's actually acting on behalf of the person. And if the court have appointed the wrong people, they need to know that there are protections in place. If the donor has appointed the wrong people, well, then that effectively, as far as the court is concerned, was the donor's fault. Obviously, there are certain routes back, whether it's through fraud and all the rest of it, but effectively it was the donor's choice as to who should be appointed. The cost of that bond is set by the court and can only be cancelled or discharged by them, so it will continue to run to be due. Once that's been paid and the bond has been secured, the court will then release the order. And once the deputies have the order, they can then start to go off to the various financial institutions with whom the donor has an interest. They might go and see Steve and say, we've got a court of protection order now appointing as deputy, so we can finally make some decisions. What's important to be aware of is that process can often take in the region of about 6 to 9 months. So that's the period of time from when the person has lost capacity and decisions can't be made to when the deputies are actually picking things up and getting moving on making decisions. So there's a significant period of time when nothing can happen there, as distinct from lasting powers of attorney, which are our insurance policy sitting in the background. As soon as somebody loses capacity or needs assistance, they're there and they're ready to be used. Now, unlike with lasting powers of attorney, it doesn't end there as far as the court of protection is concerned. Once the order is granted, the court will hand over to the Office of the Public Guardian. They're with the registration authority I mentioned earlier on in terms of LPAs. In terms of any ongoing involvement they have with attorneys appointed under LPAs, it's usually very limited. The OPG might on occasion pull out 3 or 4 lasting powers of attorney from boxes and boxes and thousands that are registered, just to check up on the attorneys and making sure they're doing what they should do. unlike with the court of protection, where they hand over and the deputies are under an obligation to liaise with the OPG and provide significant amounts of more information to them on an ongoing basis. So once the case has been handed over, the OPG will arrange an initial telephone discussion with the deputies. They will then expect a filing of the first annual summary, and then after that, they will be involved on an ongoing basis for continual supervision and submission of those annual reports. Now that differs very much from lasting powers of attorney, where almost attorneys are given a bit of a free rein and they can go off and make decisions they need to without that ongoing supervision. So then coming on to how those costs differ. So this is, as I say, more from a comparing and contrasting point of view. So lasting powers of attorney, well, there's an application fee when you register each of the documents, which is £82. So if a client is just having one power of attorney for property and financial affairs, that is the application fee. There could be a total of, so 320, I should work that out before, shouldn't I? £328 worth of application fees where a client is having 4 powers of attorney registered for them. Professional fees will range between £500 and £1,100 plus VAT, depending on how many clients we've got and how many we're putting in place. Now, you'll see where that differs quite significantly with court-appointed deputies. So the application fee there is £385. Now, that is just one application fee for one deputyship order. If additional decisions need to be made by the court, for example, to sell jointly owned property and things like that, then a further application fee needs to be paid and needs to be made on each application, which again differs from LPAs. There's the capacity assessment fee, which is often around £200. The surety bond, which is dependent on the value of the assets, but is often around £400. The annual supervision fee, again, that's dependent on the value of assets, but that's around £320 a year. And the professional fees will usually average around £1,500 plus VAT. So there are significant differences there between lasting powers of attorney and court-appointed deputyship fees. Not only initially in setup, but also annually, where we're looking at the surety bond and the annual supervision fees. Duties of attorneys and deputies, at its most basic level, they are to act in the best interest of the donor. So that it underpins effectively all of the decisions that attorneys or deputies have to make. Specifically, when acting under a lasting power of attorney, the role is to assist the donor in the management of their affairs. So it's not to take over completely, because it might be that that donor has not lost capacity and actually they just need a bit of assistance. And so therefore the role is slightly different, because under a court-appointed deputy order, it is only available obviously if a person has lost capacity, and therefore they will be taking over the management of their affairs. Now, we talked about the fact that what underpins all of this is that you must act in the best interests of the donor. As a result of that, and one thing that can sometimes get quite confused when certainly myself, and I should imagine Steve as well, talks to attorneys and deputies, is there will have been a difference between what the donor might have given instructions on and what the attorneys might be interested in. So attorneys will often be considering things such as gift giving and tax planning. Now, that's not something that a donor might necessarily give an awful lot of thought to during lifetime, because they might think, well, this isn't going to affect me. This is something that my eventual beneficiaries will have to deal with later. And it's not something I want to give over any time to, because it won't provide me with any specific benefit. So when an attorney takes over or a deputy takes over, one of the first things they might look to is, well, what might the inheritance tax position of, for example, mum or dad's estate be on death, and what are my powers to do anything about that? Well, generally speaking, the powers are incredibly limited. So, and that's true of both procedures, under both lasting powers of attorney and court-appointed deputies. So under LPAs, attorneys can make gifts, but only on customary occasions to people related to the donor. So that's birthdays, Christmas. And as a general rule, they should look back at what the donor has done before and effectively look to replicate what has happened in advance. They may also continue to make gifts to charity that a donor might have made or had been making during their lifetime. Any additional gifts to be made specifically for tax planning purposes must be approved by the court, particularly where a donor hasn't already started that process themselves, perhaps considering through a financial advisor or otherwise. So in terms of whether the Court of Protection is likely to grant authority to attorneys or deputies to make these sorts of decisions, I talked about the fact that, as with LPAs, deputies have the limited authority. Where that limited authority to make gifts for birthdays and Christmas, etc., doesn't apply, the court application is necessary. And when that court application is made, consideration is given to the value of the estate, the detriment to the patient, and to the potential benefits of the tax planning that might be made. Now, the big thing that's relevant here are the value to the estate and the detriment to the patient, because you will often find at that stage that a patient may well be in long-term ongoing care, or they might be having care provided at home. Now, that, as if any of you have had any experience of that before, is incredibly expensive, and a person will very quickly start to quote unquote burn through their assets at a rate of knots when care provision is being made. So are we likely to therefore have a successful application for gifts? So I've pulled out an example of where one particular application was successful. In that case, gifts of £7 million were approved by the court. The patient in that case, though, had assets well in excess of £10 million, and the purpose of the gift was largely for tax planning purposes. Now, you'll see there that even with a patient having £3 million left, even in one of the most expensive care homes in the area, you're not going to get close to getting to the limit there. And so therefore the court were willing to accept that. If we're talking about clients that perhaps have assets of, say, £1 to £2 million, the court are much less likely to allow authority to make gifts purely for tax planning purposes. And these rules also apply where a deputy wishes to, for example, make a loan to themselves from the patient, which is an example I've had come up before, and also vice versa, invest the patient's money in their own business, and also make sales of any property at an under or over value. So it might be that an attorney or deputy thinks that it might be in the best interests of mum or dad in this case to perhaps invest in the business, to make a loan either from one way or the other. Perhaps that's to try and hold on to the property or not. In order to do that, authority from the court will be needed. So then just coming on to actually managing the finances. So as we talked about, underpinning all of this is that it must be in the best interest of the donor. You're more likely to be able to undertake, or attorneys are anyway, specific planning where it's already been instigated by the donor. So that might be, for example, investing in business property relief assets, which is something that Steve, I know, has advised on before, and can be looked at as part of wider planning with a person's finances. And those assets, so they're distinct from making gifts by a donor, because the donor effectively is retaining control of the asset. It keeps it within their estate and within their own finances. But instead of needing, for example, to survive a gift for a period of 7 years before it's no longer removed from the estate, they only need to survive that investment for a period of 2 years. They will sometimes be riskier investments, and that's something that, again, that financial advisors would look at. So it's important that where that sort of specific planning is happening, it's already been instigated by the donor. So it might be sensible, where anybody has started to give some thought to this in the past, to actually start that conversation off, perhaps just from the point of view of making sure that somebody else is aware of your finances alongside yourself, but also to make sure that there is as wide a pool and a net as possible for your attorneys and deputies to make decisions on your behalf as possible. But also remembering, very importantly, that nothing can be done without the relevant authority, and that's either under a lasting power of attorney or under a deputyship order appointed by the court. So it wouldn't matter how well an attorney or a deputy knows myself or Steve or anybody else within the financial or other worlds. Without relevant authority in place, we cannot release any information or help to make decisions on behalf of somebody that's lost capacity. And that can be a particular issue, and I think it's been brought into focus quite recently with coronavirus. Obviously, this is not something that anybody could have expected. And although the stock market, my understanding anyway, to a degree has recovered, whether rightly or wrongly and how that stacked up, who knows. But there was certainly a stage when it dropped off the face of a cliff. Now, if you've got somebody that's lost capacity and we don't have a power of attorney in place, or we don't have a court appointed deputy order in place as well, nobody can do anything about that. So it wouldn't matter how many times you knock on Steve's door and say, Steve, look at what's going on in the markets. We need to get out of this now. We need to convert this to cash. Nobody can do anything on your behalf because there isn't the relevant authority in place to do so where that donor's lost capacity. And it might, for example, be that, as is the case with a lot of our clients at the moment, they're taking advantage of the changes to the property market and that temporary offer that Steve mentioned earlier of the stamp duty land tax holiday that's in place up to £500,000. We're finding a lot of clients putting their properties on the market at the moment to take advantage of an increase in buyers out there. And it might be that they're just unable to take advantage of that because they don't have the authority in place to do so. So I suppose really just segue onto what Steve mentioned at the end, it's all about making sure that you're controlling what you're able to, having the right things in place and having the right people in place to make those decisions and help you make those decisions, but also making sure that they're aware of what your finances consist of and making sure that they have as wide a power as possible. So that's it from me. The only thing actually that is left for me to say, and something I forgot to mention, as Steve probably clocked, and I should imagine Vicky did along the way, was we had a couple of questions that we were going to ask. The first of which, and which Vicky will bring up for you in just a minute, is which of you has a lasting power of attorney in place? It would be good to get an answer on that. And also, secondly, who of you are acting as attorneys already on behalf of somebody else? It would just be good to see what everybody's position is and how you've interacted with these sorts of things before. But otherwise, that's it from me at the moment. I'll hand back over to Steve, who I believe has probably been looking through a few questions that might have come up, and we'll see where we can provide answers at the moment. If there's anything specific or that we need to keep confidential, it might be that we will answer those afterwards and we can contact each of you by email and things like that. But I'll hand back over to Steve now. Thanks very much.
Thank you very much, Simon. Both of us talk for a lot longer than we think we're going to talk, so apologies for that. The 86% of attendees do not have an LPA in place at the moment. That was the result there of the first poll. Vicky, if you could put the other one up whilst I'm just closing off. My question, I had two which you answered when we went through the gifting section there at the end, Simon, but one that I'm commonly asked by clients, or a common misconception, is that powers of attorney have some bearing on who is executor under a will. Can you just confirm the position on what happens with an LPA, a lasting power of attorney, when the donor dies?
Yeah.
And is there any connection at all with how that person's estate is then dealt with?
Yeah, so you're quite right. There's no connection whatsoever. So a power of attorney, whether it's an enduring power of attorney, a lasting power of attorney, or a deputy appointed under a court order, specifically only has effect and is valid during a person's lifetime. So as soon as a person dies, any authority they had under that power is completely revoked and any further decisions are void. Instead, the power then hands over to any executors named in a will. So that's a very different document and something that deals with the appointment of them on death, really.
Great, thank you for that, Simon. And just the result there of that final poll, we have 20% of attendees are currently acting or appointed to act as attorneys for someone else. So 1 in 5 of our attendees are attorneys for someone else, friend, loved one, etc. So thank you very much for that. We will follow up the session with some contact information for both myself and Simon for anybody who'd like to discuss any of the bits we've covered in more detail. And if anyone wants to look at putting in place an LPA, we'll give some information there. And please feel free to contact Simon. He will have an initial chat with you out of the goodness of his own heart before you go ahead and appoint him if you've got any questions. We'll also send out a link to this presentation if you want to watch it back or remind yourself of any points. So if anyone wants any further information, watch out for an email from us over the next few working days, over the next week, and we'll be very pleased to come back to you. So thank you very much for everyone who's attended, and we both wish you all a good rest of the day. Thanks for attending.